Thanks for joining us, folks, for the webinar. We've got a 45-minute webinar today on our interim report from the Productivity Commission on harnessing data and digital technology. First thing I'd like to do is to acknowledge the traditional owners of the lands where we're based today. I suspect we've got people all throughout the country. I'm coming to you from Wurundjeri land in Naarm. I won't try and even start running through from the PC stuff because we've got them all over Australia as well. But can I pay my respects to elders past, present and emerging, and to any First Nations people who are joining us today. Just a bit of background first, the data and digital opportunity. I like to think about it that we're really still part of a process of technology change and growth that really started about 250 years ago with the steam engine. Digital and data has really been, it's had an impact on everyday lives really since about the 1990s. And for those of you who are old enough as I am, you can remember that that's pre-internet being common, pre-email being common. Internet and mobile phone, big impact on GDP per capita, about 3% for over that decade, 2004, 2014. Today, we're looking at an economy where digital activity contributes about 6% of GDP. What are we looking at in the future? We've looked at AI. There's a range of estimates around AI, from the pessimistic by Nobel Prize winner Daron Acemoglu through to the very optimistic by Philippe Aghion from Harvard and some other academics. We've been fairly conservative to come up with this number of about 116 billion addition to GDP. It works out at about a 4.3% increase in GDP. So that's a reward and time frame we're looking at, say, over the next 10 years, this will evolve. But in about 10 years' time, every person in Australia could be around $4,300 better off if we are able to seize this AI opportunity. And that's using Acemoglu's type of framework, so it's pretty conservative. Data is the feedstock of AI, and having a mature data sharing regime could also by itself add another 10 billion to our GDP. The parts of our inquiry really all fit together with each other. So we've got AI over on the right-hand side there, and proportionate AI policy is an important input. And I'll explain what we mean by that. We do not mean light-handed or light touch or the other things. I'll explain what we actually mean by AI policy in a minute. But then privacy, digital financial reporting, data access pathways, they all feed together to lead to higher productivity. And we've got a little roadmap here to try and help that. So if we move to the next slide, just to show where we are in the process, this is a draft or an interim report by the Productivity Commission. That means we are very keen on getting more feedback on our discussion, on our draft recommendations. We've put in explicit information requests into our interim report, for example, around copyright, which we'll get to. And we're keen to get that fairly quickly because we need to get this report to the Treasurer before the end of the year. So you'll all be aware that this report is going to feed into the Productivity Roundtable, but that's not the end of the story. We're really looking at finalising those recommendations, getting a set of recommendations to government before the end of the year. Okay, so let's move on to the first area, which is artificial intelligence. And if we flick on to the next slide, the important thing to understand about artificial intelligence, other than the fact it's a terrible term that goes back to the 1950s, is that it's already being used in all sorts of really interesting ways. Some of you will be aware of its use, helping teachers, for example, with lesson planning, some overseas applications where it's being used to be able to have students, for example, learn at their own pace, moderated by the teacher. You'd be aware of examples in medicine with imagery and the improvements where you've got a radiologist and the AI working together, and the improved ability to, for example, check scans for cancer and improve the ability to find medical issues and get the treatment earlier. Software code's a big one that's been done. Again, many people would know that our banking system is already using AI for fraud detection. Anyone who uses Google Maps or any of the mapping software or any standard word processing software would be using AI because they're built into those software packages. Things like spell checker, grammar checker, predictive text, they're all based on AI. Great examples that we found about during this inquiry. For example, use on farms and use by farmers to improve their ability to manage their crops, manage their machinery, and, for example, sorting out, in this particular case, avocados were mentioned here, to better identify which are the ones that should go through to the marketplaces for people to be able to buy and which are damaged and shouldn't be passed through. Another great example was the use of AI to help identify from drone imagery likely places for Aboriginal rock art that had been forgotten about and rediscovering them. Use for environmental purposes, again, using imagery, drone type imagery, satellite type imagery, to be able to identify fishing net waste and help protect our marine life from being tangled in that waste. So they're the sort of backgrounds that feed into that 4.3% boost to labour productivity and to GDP over the next decade. So how is our approach to AI regulation? It is definitely not a light touch. Rather, we have said we shouldn't be starting with an AI Act or a general AI set of rules across the entire economy. And the reason for that is pretty simple. Those sorts of general AI Acts, one, they are not nuanced to individual circumstances and to the individual harms from AI that can arise from AI. Secondly, they create more uncertainty for business and for consumers. And thirdly, they will lead to court cases. And we've seen that in the EU, where there's just ongoing fights in court over exactly what the EU's AI Act means. So what's our alternative that we've put forward here? Most of the harms that people identify with AI are harms that can already occur. It's just that AI can make it easier, cheaper, faster for bad actors to engage in those harms. So what we've suggested is an alternative approach where we say, let's identify those harms that we think are associated with AI. Then let's look at the individual laws, because particularly where those harms are already illegal, let's look at our individual laws and check, are those laws up to speed for AI being involved in those harms? So whether it's medical equipment, for example, the TGA already licenses medical equipment, so is able to look and see, are our medical equipment laws able to handle AI-based equipment? Our consumer laws. So there's a lot of talk about misleading and deceptive conduct facilitated by AI. Misleading and deceptive conduct is already illegal in Australia. So what we need to do is check that those consumer laws are capable or up to speed to be able to deal with AI. When we check there, are there gaps? Are there gaps in the existing law that need to be filled? If so, let's start off by filling those gaps in existing law. What about our regulators? Let's make sure our regulators are resourced to be able to deal with this new challenge. Let's make sure that they have the expertise to be able to deal with the challenge. So make sure our existing laws are up to speed, make sure our regulators are up to speed. There will be situations where the harms from AI and the risks from AI are not covered by existing laws. In those situations, we need to look at developing new laws. But wherever possible, those new laws need to be technologically neutral. As somebody who, again, is old enough to remember the early days of telecommunications regulation in the 1990s, lots of regulation about fixed line telephone networks, all completely obsolete, made obsolete by mobile phones within about a decade. So we don't want that same situation with AI laws. Imagine that we'd been sitting 10 years ago and we'd said, let's design AI specific laws. We'd now be looking back and saying that's ridiculous. AI is completely different today to what it was 10 years ago. Remember, in 10 years' time, they'll probably be looking back the same way. So wherever possible, make those new laws technology neutral so that they will last the distance. You don't want to have to be in 5 or 6 years' time saying, oh, that doesn't work anymore. Only if we cannot do technology neutral laws do we need AI specific laws. Copyright. We pick copyright as an example of where we think this sort of discussion is needed. How does AI change the story for copyright? AI training uses copies of copyright material on the servers, on the clouds, that are used to train the AI. So we're not talking here about the AI reproducing as an output copyright material. Some of you will be aware of the New York Times case that's already occurring around that sort of reproduction of material. What we're talking about here is the use of copyright material for training AI models, both broad general AI models, large language models, but I think more importantly for Australia, for the small models that will be built on top of those AI engines. For example, one I've been using is, imagine an app that looks at Australian poetry. That app would need to be able to make copies of existing Australian poetry to be able to train the AI model for that small AI application. Are our current copyright laws fit for purpose? So this is a general question that we think needs to be asked about all our regulation. This is an example of it. We got significant amounts of commentary on it from all sides. We have heard from the AI application creators in Australia who've simply said, well, look, at the moment with the current copyright laws, the current fair dealing exemption without a text and data mining as part of that exemption in Australia, they've said, look, we'll just go overseas. We'll train these models overseas. We won't do it in Australia, and Australian copyright holders will have no recourse because the activity, the copying, will be done outside the country. We've heard from copyright holders who have said, this is theft. This is harming Australian creatives. We agree with that. The issue here is that we are probably in, with regards to copyright, the worst of possible worlds. Our creatives aren't getting compensation when their material is being used to train, for example, small AI models. And that training isn't occurring in Australia. So the tech jobs are going overseas. So what we're hoping to get feedback on is the way forward on this. Now, one way forward might be to have a text and data mining exemption as part of our AI laws. But that's not the only way forward. And if you look through our report, you'll see there's other suggestions put forward. For example, can licensing work? We've seen licensing be used for small AI applications overseas. For example, an example that I'll use where it's occurring, an AI application in medicine overseas has a deal with the New England Journal of Medicine, one of the top medical journals in the world, to be able to use their academic work to feed in to a medicine application, a lot better than Dr. Google. If we had that poetry application, is it the case that publishers in Australia of those poetry works would be able to seek agreements with the tech companies to get licensing? Is that a better solution? We have solutions for dispersed creatives in other areas, such as collection societies that we use already in, for example, for music that's played in retail outlets. So what we're after here is feedback about whether there's need for any reform. Maybe our current law's fine. If so, please put the case and please put the arguments as to why it's working. Or do we need reforms to our current reform? And if so, what? To make sure that copyright is getting the right balance between the tech companies and the consumer benefits from the tech and the rewards for creatives. Because the last thing we want to do is end up in a world where the creatives in Australia are just out of work and we're not getting that creative content created, because that, again, is a terrible outcome for everybody. So please give us feedback on that. Data access. I think the best way of thinking about this is think of, every time you hear of a data breach and you say, oh, my data's out there. Data about me is being held by all sorts of parties. They're using it for all sorts of reasons, internally to create value. Sometimes they're trading it. And I know as a consumer, but sometimes it seems like everybody out there has data about me and is using it to create value, except for me. And that's the starting point here. What we want to do is think about how do we allow individuals, and those individuals can be consumers, it can also be businesses, because there's a lot of small businesses out there, for example, that have data about them held by third parties and they can't get access to it. So how can individuals get access to the data about them that is being held about by third parties so that they can create value from it? So what sort of value are we talking about? Well, it can be switching between providers. For example, you've already got cases where you can use financial data to help move across, provide information to other financial product providers to make it easier to switch. Linking related products and services. So often third parties, and we've seen this overseas, for example, in the UK under their open banking, you often have third parties creating really innovative applications, bringing data from different sources together and providing you, the individual, with insights from that data about you, which you otherwise wouldn't have been able to get, and more personalized services, being able to use that data so that the parties who are trying to provide good quality services to you have the information they need to provide those services to you. It could be something as simple as being able to fix your car properly. And we'll get to that as an application. And we're looking at, about 10 billion as being an estimate of the sort of benefit that this could create for our GDP. Now, some of you will know we already do have some regimes that enable individuals to get access to the data about them. The most obvious one's the consumer data right, which is an application in banking. It's also in energy. We're seeing some great uses of that, by the way, but it is very compliance based. It is pretty heavy handed. And interestingly, it actually doesn't often empower the individual. So for example, it will allow information from one financial institution to be passed across at your request to another accredited financial institution, but you can't say, well, I also want it to go off to this other use over here. So that's on the right-hand side here. Working well, you want those sort of protections when you're dealing with very sensitive data like financial data. So we don't see getting rid of that in any sense. What we would like to see is easier, faster, cheaper ways for individuals to be able to get the value out of their data, out of the data about them in other areas, often where that data is not going to be nearly as sensitive as financial data. We've got a couple of examples over on the left-hand side here of sort of what we call new pathways. So for example, if you're a member of a retail reward scheme, such as a supermarket reward scheme, that means that the relevant retailer has lots of information about you and your spending patterns. You can get that often, but often in a way that is pretty useless from your perspective, a PDF or sometimes even just a printout. What would be great is if you were able to get a machine readable form of that data, not continuously, not in real time, but perhaps once a month, and then be able to have, say, a third-party application bring that data together over your different retail activity, perhaps together with some data about your spending patterns, your time of life, your plans over the next 6 months, just so that you can manage your own life better. And that could be as simple as sort of saying, hey, maybe you don't want to buy the 4 litres of milk this week because you're away next week. Maybe you can do the 2 litres for your family. And to someone who's just come back from being overseas for 3 weeks, that would have been really useful before I left and ended up having to throw stuff down the drain. That's one type of transfer. Another would be a continuous data feed. So the sort of thing we're thinking of here, if you've got a modern vehicle, you may or may not know that that vehicle collects lots of information from you and about your driving habits, your braking, the state of the vehicle. Often that data is then used by the manufacturers for their own servicing purposes, and the PC's previously done a right of repair inquiry, which Julie was part of, to try and open up that data to make sure that it's available if you want to get your car or your vehicle, or if you're a farmer, your agricultural equipment serviced elsewhere. But it's also, for example, currently sold on to insurance companies and to other parties. And it would be great if you could get that data and say, hey, this shows what a great driver I am. I can use this to get a better insurance price, a better price from my car insurer. If you're a farmer, hey, I can use this so that I'm changing equipment supplier. I think this other combine harvester is better, but I am able to feed in the data from my last 4 or 5 harvests so that this smart combine harvester is able to better understand the pattern of cropping in my fields. That's the sort of thing that can help individuals and can help business. These are, again, some more, I've sort of run through those. The one I haven't run through actually is the one in the middle, tenancy data. If you're a tenant, if you're renting, then you'll know that sometimes getting access to that tenancy ledger in a form that you can use for, say, providing to a bank to get a loan, or convincing a new landlord through their real estate agent that you're going to be a good tenant, that can be pretty tricky to get. It's sometimes really hard to understand. Just again, having a simplified standard form, easy to access, that tenants can get access to their history of their own rental payments, which sounds pretty fair to me. Privacy regulation. So what have we heard in privacy? Really interesting that you talk to business and they say, oh, the privacy laws, they're so burdensome. We've got some figures, unfortunately, only for a fairly small set of companies from larger companies, because they're the ones we could get data on. But the compliance figures for even these companies came to about $2 billion per year for the Privacy Act. And if you start including a lot of smaller businesses, it's likely the number would be much, much higher. So business says the current Privacy Act, it's creating a lot of regulatory burden for us. Yeah, in some ways, our response is, well, cry me a river until you talk to the people who are meant to be protected. They say, well, the only problem is the Privacy Act seems to be some form of self-managed act. We have to read these privacy statements on the internet. The ACCC estimated that if consumers actually read all of the privacy terms and conditions they're faced with over a month, would take, I think they said, about 36 hours a month. Basically about a week of work every month just to stay on top of the privacy conditions. Maybe somebody does that. I'm afraid I fall into the same trap as I suspect many of you do, but you end up ticking the box. You get faced with this unreadable legal complexity, and they say, look, if you tick the box, you're going to have the service. And I'm just ticking the box. And you probably have absolutely no idea of what you've just handed over or you're allowing to be taken by the service provider. So on one hand, you have businesses saying this is burdensome. On the other, you have the consumer saying this doesn't offer any real protection. That's a problem. How do we try and fix this? Well, there's a number of different ways that we could try and do it. But what we would like to see happen is a focus on the outcomes. So a focus for business on being able to say, either as their primary obligation, which is that middle path there, or as a defence to the current Privacy Act, a potential breach of the current Privacy Act, as a defence, which is the left-hand one here. We would like business to be able to say, look, we've focused on the outcomes. We have taken best endeavours. We have tried to act in the consumer's interest, in their best interest. And by doing that, business can say, yep, we can protect privacy, we can protect our consumers' privacy, even though we may not be literally following the multiple Australian privacy principles and the ticker box approach that's come out of the Privacy Act. Just to give you an idea of what we're getting at here. And again, we want your feedback on this. This is an interim report, remember. We could have a best interest obligation around privacy. So a company has to take the consumer's best interest into account when handling their data. That has different legal levels. I'm not the lawyer, Julie is, so I'll let her weep into her hands as I try and explain these. You can require the company to act in the best interest, and we've got a water spill type example. So if there's water spilled on the form, how does someone act in the best interest? Well, they mop up the spill. What about having regard to the best interest, which is a lower legal hurdle? Then they have to show that they've considered mopping up the spill, what are the costs and benefits of mopping up that spill. Or they can have a duty of care, which is they'd put up a warning sign to passers-by about the spill. And similarly, you can have that same sort of situation around privacy. For example, a data breach. If there's been a data breach, act in the best interest. Well, that means locking the individual's accounts, making sure that they can't be hacked due to the data breach. Having regard to the best interest, consider locking down those individual accounts. Duty of care, notifying the individuals. So if we have these alternative approaches, which we think will make it better for business and for consumers, which direction should we take? Which of those pathways, and to what degree should there be an act in best interest, regard to best interest, or a duty of care? We've also looked, so some of you who follow the Privacy Act will know there's been recently a Privacy Act review, and some reforms to the Privacy Act have already been passed. There are some second tranche reforms. Now, we have not gone through those in detail, but there were a couple there that we thought were worth commenting on. One in particular is the right to erasure. This is not a new concept. It comes out of the General Data Protection Regulation in the EU. So it's been in place not quite a decade in the EU. It's probably been in place effectively about 6 years, I think, over in the EU. Unfortunately, it's ended up being pretty burdensome, I think is the best way of putting it, in terms of productivity outcomes for the EU. There's quite a bit of economic literature, and yes, some people say, look, it's too soon to be certain about this, but most of the indicators are pointing in the wrong direction. And the indicators are that this is reducing privacy and reducing competition, because the burden really falls on a small group of companies, often small business, but for example, media organisations say this is a very hard burden for them when you've got media material that's been produced, it's been archived, it's been distributed, and all of a sudden the burden comes back on the media company to say, well, all that material relating to this person has to be erased. That can be pretty difficult. We also currently have not a right to erasure, but our Australian Privacy Principle 11 already requires firms or businesses to take reasonable steps to destroy information or ensure that it's de-identified, destroyed when it's no longer needed. So we seem to already have a protection in there. It's been suggested we put another protection. The best experience from overseas with that protection is it can be pretty tough, and big firms can deal with it, but it hurts smaller business. So we don't think it's the right idea. But again, if you think we're wrong, give us feedback. Next slide, please, Louisa. And flick over one, digital financial reporting. Just very quickly on this, we have voluntary digital financial reporting in Australia at the moment. That has meant that the number of digital financial reports that have been uploaded to ASIC in Australia over the last, I think it's around 12 years that this has been possible, the number is 0. Nobody has used this possibility. The reasons are pretty clear. The benefits to any individual business from digital financial reporting depend on lots of businesses doing digital financial reporting. The benefits come about because businesses can better use financial reports from their competitors, from the other businesses, to work out how they're going if those other businesses also have digital financial reports. Analysts can better use it rather than trying to re-key in paper-based or PDF-based financial reports. They can be much more efficient if there's a mass of companies doing digital financial reporting. Similarly, government and regulators, they can only rely on digital financial reporting to regulate business if lots of businesses are doing it. So at the moment, we've got a chicken and egg problem. Nobody's doing something because nobody else is doing something. What we've seen overseas, so for example, the US has had digital financial reporting since about 2008 as being a requirement on companies. Most countries such as the UK, EU and so on, similarly require digital financial reporting by companies. Those countries are already getting the benefits. Other countries like Australia that have tried saying, oh, look, we'll do it voluntarily, it just hasn't worked. Canada does it voluntarily. They've had a couple, they're better than us. They've actually had a couple of digital financial reports provided, but it's still a tiny, tiny fraction of their companies. There is a cost to companies, but there are now internationally recognised standard languages that companies can use. The relevant processes are built into most business software. So we think that it stands up to the cost-benefit analysis, and we think that digital financial reporting in Australia for Australian companies should become the default. So it should be digital by default. I suspect I've ducked over a couple of these. So yeah, these are the sort of benefits: auditors, report preparers, regulators, or a few shareholders, or another group who can gain here. All of those groups can gain from digital financial reporting, which they're not getting those benefits at the moment. As I already noted, there are some costs. They're not excessive. They have fallen over time. We really do need it to be the default to get uptake of this digital financial reporting. And there aren't substitutes at the moment. Some parties have come back and said, oh, well, now you can just run PDFs through AI. Yeah, that doesn't quite work because, again, you need the standardization associated with digital financial reporting to get the real benefits. So there isn't a sort of a backdoor way to get the benefits without the costs. That just doesn't exist. We'll open it up for questions. I'll pass over to Julie to see what questions, and we'll try and cover. There's almost certainly a lot on copyright. If you want more on copyright, by the way, Julie and I did do an op-ed in today's Australian, which is annoyingly paywalled, but it is available on the Productivity Commission website. So have a look there, and that may give you a better idea about, quite frankly, what we think has been a bit of a misleading sort of debate that's occurred over the last week. And, yeah, again, we're not recommending at the moment anything for copyright laws. We want feedback on the best way forward. Okay, questions about AI. Let's start there. Are you examining the impact of AI on wealth and income distribution? Do you want me to answer that one actually, Julie, or would you prefer?
I can make a start.
Yeah, go for it. Go for it. Yeah.
Apologies, people. No, look, we haven't looked at that directly, and we do have some comments on that if you wanted to look at box 1.4 in our report. Stephen, did you want to add anything?
Yeah, so we haven't looked at it directly. We are aware of the debate around jobs and AI. Actually got a slide we didn't put up in the slide pack for time constraints. Yeah, so this is actually from a very reasonably recent article, basically looking at the 1940s to 2020s and saying, well, what new jobs are being created due to technology change and what jobs have disappeared. See, it shows across the US just the new jobs that have been created by since 1940s, literally jobs that did not exist, and it breaks it down by different areas. So you'll see management is one of the areas where there's not been a lot. Other areas, and apologies because I can't see it, I think farming is one, for example, where there's been lots of new jobs created. Technology has this pattern over time. It creates new jobs, but it also destroys some jobs. It tends to create more jobs than it destroys, but that doesn't help people who lose their jobs or whose careers are suddenly diminished or ended by the technology change. And that's been going on for 250 years. We need to recognize that. And we need to recognize that those people who do lose their jobs, who lose out from this tech revolution that we're currently in, they need to be supported. They need, where they want, retraining. We need to make sure our welfare and our social safety nets are up to scratch for those people. So, yeah, not trying to gloss over this in any sense. Some people will be worse off. That's always been the case with technology change for 250 years. We need to make sure we've got a society that can help those people get back on their feet, get back into gainful employment and make contributions. Julie, can you comment about why there appear to be no real coverage about the benefits from better data access to information by businesses?
Well, I think that we were very struck when we looked at the consumer data right and the My Health records particularly consumer data right. One of the biggest issues was about data coming directly to the consumer. But we're very interested in hearing about business applications. Certainly, we spoke to a number of businesses during the course of the inquiry. So whilst we talk about consumers, we're also thinking that business would also have greater access to data through the type of processes we talked about.
Is the other aspect of having AI trained on Australian culture and thought reflected in AI being considered as important?
Well, I think, Stephen, you made the really good point earlier that creative industries are really important and our sense of self as Australians is really important. So what we're asking is about some of the ways in which we might deal with the copyright issues. So we're very open to people talking to us further about that, but we've always been, we're supportive of the creative issues.
Yeah, and just to add to that, because there is a question in there about stuff being done overseas. Are we suggesting creators should refuse to give it away or give it away for free? Or and no. What I mean by the worst of all possible worlds at the moment is that other countries don't necessarily have the same sort of copyright protections we have here in Australia, and because the issue is that it's the breach of copyright when the material is copied onto the server used to train the AI, it means it's the local copyright law that matters for that what we'd consider a breach. And if the local copyright law in various countries is not at the same standard as Australia, tech companies can avoid paying Australian creatives under our copyright law simply by changing jurisdiction. So that's really where the problem comes in. And yeah, we want to solve it because it doesn't help our creators, it doesn't help our tech industry. Another one. So Julie, is the interaction between AI and intellectual property rights and competition law being addressed by the PC?
Well, Stephen, as I understand it, this was actually an issue which was looked at by the ACCC in their digital platforms inquiry.
Yep. Yeah. And I think the last one, volume 10, was released earlier on this year. So there's a lot of stuff in there in those AI reports around those competition issues. Why does the interim report why does it not look at collective licensing when that is already emerging and Australian authors have already earned income from such arrangements?
Well, actually, we've put some options on the table. So if you have some views about the collecting societies, we're all ears. We're really interested in thinking about how that would work in terms of of AI.
Yeah, and interestingly, a lot of feedback we got, when we started floating these sort of ideas, the tech companies said, "Oh, just TDM exemption." The creatives said, no change." And it was perhaps only when we really started pushing, "Hey guys, no change doesn't help the creatives. How do we actually get the benefits that issues such as collective using the collecting societies, which already occur in other areas, using publisher licensing, which we've seen overseas." It's really when those really started bubbling up, and what hopefully the current debate, the debate over the last week, has done is it's got you all thinking about that stuff, or those of you interested in that area, it's got you thinking about that stuff. We need help to make sure we get to the best solution, and that's what this interim report is about. Look, thank you to the 338 people who have stayed for the full time. You guys all have a great rest of your day. Thanks.
Thank you. Thanks.